Good day, Crime Talk aficionados. We have a great show for you today. First, Lori Vallow refuses to go to court. The defendant takes the stand in the trial of the Cash App founder murder trial. A mom catches a predator. A cold case has finally been solved. We have a Daniel Penny trial update. Hashtag free Daniel Penny. A man commits heinous murders in California. We'll give you a hint. It involves guns and flames. We have a lot of this day in legal history information for you, and our dumb criminal of the day, well, they win points for creativity. Let's talk about it.
All right, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment. Hit that little bell for notifications. And yes, you can always check us out on any of your favorite podcasting apps. Before we get to the docket today, please go to crimetalksearch.com. You can sign up for that background subscription service today, and you can cancel at any time if you choose to do so. But while you have that subscription, you can do as many background searches on anyone here in the United States that your heart desires. And you are going to get a report literally prepared while you wait and then emailed to you. And you can get updates as well if information is updated. And you're going to find out if they are maybe on one of those public lists that you have to register for. Their criminal history. Are they married? Are they divorced? Why do they have so many emails? You're going to find out that kind of information. So if somebody new is coming into your life, go to crimetalksearch.com. You're going to be happy that you did. All right, let's go ahead and open the record for November 14th, ladies and gentlemen. November 14th, 2024. Can you believe it is already November 14th? Where has the year gone? Well, I know who's got a lot of time to think about where the year has gone, and that is Lori Vallow. Well, Lori Vallow had a hearing this morning, but she decided she wasn't going to show up. It was a hearing to address the issue of competency, to see whether she is competent to take the stand and testify and have the case proceed forward. Now, as you may recall, she was deemed incompetent for 10 months in her case in Idaho, where she was ultimately convicted in regards to the death of her children, JJ and Tylee, and her now fifth husband's former wife, Tammy Daybell. Once she got restored to competency, she said, full steam ahead, let's go to trial. Well, then she's got this case down in Arizona where she is accused of killing husband number 4, along with her now deceased brother, and also taking shots at her niece's brother-in-law. The woman just has drama everywhere she goes. She is a black widow indeed. Anyway, her attorneys down there in Arizona filed a motion, what they call Rule 11 down there in Arizona, saying we have concerns about her competency. Judge, do the evaluations. Well, then she gets a couple of new attorneys. They want to withdraw the motion as it relates to competency, and that's why we were supposed to have a hearing today. But she refused to come. Now, I always find it interesting when a defendant refuses to come to court, but they can. A lot of times the sheriffs say, you know what, you don't want to go to court? No harm, no foul with us. Judges say, fine, we'll just keep resetting it. But ultimately, judges can issue a drag order, which means bring the defendant to jail by force. Remove them from the cell, shackle them to a chair if you have to, but bring them to court because we are going to have these proceedings move forward. Well, like I said, Lori Vallow didn't show up today, but we'll see if she doesn't show up again on December 5th. We'll just have to see how she handles the situation. Next on the docket, the trial as it relates to the Cash App founder, the murder trial. Well, the defendant takes the stand. That's right. The defendant charged with the stabbing death of the founder of Cash App, Bob Lee, has told the jury he was defending himself after he made a bad joke and Lee suddenly attacked him. Well, Nims Momeni told the court that his altercation with Lee began after he joked that the software engineer might want to spend his final night in San Francisco with family rather than trying to find a strip club. It was at that point that Momeni testified that Lee pulled out a knife and attacked him, forcing him to defend himself. Now, Lee was later found fatally stabbed in downtown San Francisco back in April of 2023. He was later rushed to the hospital, but he ultimately died. Well, Momeni has pled not guilty, and he looks at some 26 years to life in prison if he is in fact convicted for the murder. But Momeni said Lee later walked away, showing no signs that he was injured at all. And then Momeni says he called an attorney the following day when he learned that Lee was dead. Well, there is some video from the night that shows the two men exiting a car in an isolated spot in the Bay Bridge area. Now, prosecutors say this is where Momeni stabbed Lee, while the defense says that's where Lee attacked Momeni. The jury will decide who attacked whom, if at all. Anyway, the defense claims Lee was being erratic and aggressive and having slept only 6 hours over a 4-day period because of cocaine and ketamine, along with a bunch of alcohol binging. So when Momeni took the witness stand on Wednesday, he recalled the events of what happened back in April of 2023, and he said the two men were just on friendly terms when his sister, Kazir Momeni, kicked them both out of their condo at 2 a.m. because she wanted to go to sleep. Momeni said that they got into the BMW and they started to drive while Lee checked his phone for places to go next. He pulled the car over after they went over a pothole, causing Lee to spill his beer. Lee got out of the car and Momeni followed, thinking Lee was going to get sick, puke. Well, that was when he said he made the bad joke about seeing his family. He just went from 0 to 100, Mr. Momeni testified, and he testified that you could just see the anger. Anyway, the district attorney questioned Mr. Momeni on cross-examination, said, hey, just want to make this clear. What you're saying is that this man killed you because of a bad joke. Well, Mr. Momeni responded, I'm not sure why he pulled the knife out. I was in fear for my life. Mr. Momeni's been prepped very well, I might add. Anyway, Mr. Momeni pushed back yesterday as the prosecutors questioned him about the text messages and testimonies from others, and the cross-examination was going to continue today as well. Now, there was video surveillance of Lee's final night showing him entering the Millennium Tower downtown, where Momeni's sister lives with her husband, a prominent plastic surgeon. Well, the video also shows Lee and Momeni leaving the building at 2 a.m., and driving off together in Mr. Momeni's car. Now, police were able to recover a knife that was about 4 inches long in a secluded area where Lee was stabbed. And our prosecutor said the test showed that Momeni's DNA was on the weapon's handle and Lee's DNA on the body of the blade. But the defense presented an expert witness who said the police should have tested the handle for fingerprints of Lee to see if it was there. They didn't. I don't know. It's going to be a question of fact, ladies and gentlemen. That's what you love about good old self-defense cases. I did it, but I was justified. The dead guy deserved killing because I was in fear of death or serious bodily injury. And obviously, Mr. Momeni has been trained very well, or prepped. Let's say, why don't we use the word trained? He's been prepared very well to say, I'm not sure what he did. All I know is, though, he scared the hell out of me, and I was in fear of death or serious bodily injury. That's my story, and I'm sticking to it. Next, a mom catches a predator. That's right. The Jacksonville, Florida police were involved in a shooting last month where an officer wounded an 18-year-old man who the sheriff said brandished a pistol after the mother confronted him about trying to meet up with her 13-year-old daughter. Yes, that's right. Mamas protect their babies, ladies and gentlemen. Anyway, the chief of police down there, a guy by the name of Alan Parker, said all this began with a mother being alerted that the 18-year-old boy had been texting her daughter. So she got on the phone with him, believing that this was in fact the daughter, and arranged to meet him at 7 a.m. at the Popeyes. She showed up with her daughter and her 11-year-old son, but instead confronts them. The kid confronts them with a pistol in his waistband, lifts it, and says, when you hear the shots tonight, you'll know what's up, according to the police chief. Well, needless to say, mom took her children inside the Popeyes to call the police, and the 18-year-old man went around the back of the restaurant when an officer pulled up in the back. That's when the 18-year-old was still there, even though he had had plenty of time to park. Now, the officer ordered him to turn around and show his hands, but he slowly turned his back to the officer, and he takes off running, apparently. around the back of the business. It's all according to the police chief. So the officer takes off in foot pursuit, and as he hits the corner, he sees the suspect pull the pistol from his waistband. He yells, "Drop, stop, gun, gun, gun," engages the suspect, and shoots the suspect multiple times. The suspect, while being shot, continues around the neighborhood businesses, then drops his gun, and he continues running, and the cops ultimately lose sight of him. Now, another officer had set up a perimeter and brought a canine into the search, but then they soon found the young man in a drainage culvert. They called him out without further incident and began medical assistance. Now, he was shot in the torso, hand, and possibly the leg, but he was in stable position, according to the police chief. The police chief did say it doesn't appear that the young man had exchanged gunfire with the officer, but the detectives did recover the gun. Now, the 18-year-old was identified as Sari Rodriguez Banks. The officer was identified by the name of Garrison Robinson, and he's never been involved in a shooting before. But Mr. Banks, although he's doing okay, he's going to live, he's being held on a $700,000 bond as he recovers in the hospital and is in stable conditions. Now, he has also been charged with aggravated assault with a deadly weapon on the police officer, lewd and lascivious conduct by an offender over 18 against a victim less than 16, unlawful use of two-way communication devices, and traveling to meet after using a computer to lure/solicit a child. You gotta love a mom protecting her babies. Probably should have called the police, not just going there to confront somebody, but I get it. And then it didn't turn out well for the young man. What can you say? Next on the docket, let's talk about the Laken Riley murder trial. That's right. Back in the morning of February 22nd, back in Athens, Georgia, it was a typical morning there in the college town, but there was a brutal attack that obviously sent shockwaves through the city. Laken Hope Riley, the former University of Georgia student enrolled at the Athens-based nursing program run by the Augusta College, went on a run that morning, and that outing ended with her violent death on the University of Georgia Intramural Fields complex near the College Station Road. So on Friday, the details of the killing are expected to unfold as the man charged with her murder will have a bench trial before a judge there in Clark County Superior Court. Now, Jose Antonio Ibarra, he's only 26 years old. He requested a trial to the court over a trial by jury because jury selection was just a day away when he announced in court that he waived his right to a jury trial and would submit himself to a trial to the court before Judge Patrick Haggard, who will decide not only whether he's guilty of the death of Laken Riley, but what his sentence should be. The charges against Mr. Ibarra are extensive. They include malice and felony murder, aggravated assault with intent to rape, aggravated battery, hindering a person making a 911 call, and also being a peeping Tom. Well, the district attorney filed a notice back in May of this year saying that they were not going to pursue the death penalty in this particular case. Well, in this trial to the court, the judge is expected to hear from the state's evidence presented by the special prosecutor, Sheila Ross, who comes from the Prosecuting Attorneys Council in Atlanta. Now, Mr. Ibarra's case will be presented by his defense attorneys. He's got 3 of them. Anyway, the evidence is expected to begin with the day that Riley's body was found. Now, after the 22-year-old nursing student left for a jog on campus, the University of Georgia police had reported that a friend became concerned when she didn't return so she called the police. Police found Miss Riley's body shortly after noon in the woods near Lake Herrick. At that time, the police would only say that they observed visible injuries, according to early police press releases. Now, police apparently attempted life-saving measures, but reports show that she was unresponsive and had such extensive injuries to her head that she had been beaten with a blunt object. Now, the University of Georgia police there in Athens, Clark, and others have identified possible suspects as a man was seen putting a jacket and latex gloves smeared with blood in a trash bin near some apartments nearby. Now, the name of the apartments were subsequently changed, but the day after the slaying, the Athens Clark police officer spotted a man wearing a baseball cap just like the unidentified suspect was identified at the dumpster. Now, the man allegedly was Diego Ibarra, a brother of Jose Ibarra, and from that point, the police located Jose Ibarra there at the Celio Apartments. In the ongoing investigation, officers reported he observed wounds on the suspect, led to the arrest of Mr. Ibarra, and a news conference followed, and the University of Georgia police chief announced that there was an arrest. Now, since his arrest, several hearings regarding evidence have been held by the Judge Haggard, who then set the November 18th as the start of the jury trial date. In the response, I guess you could say, as it relates to the University of Georgia, they announced they were going to spend $7.3 million on safety upgrades on campus, and the city of Athens announced another $500,000 would be spent on security enhancements. So like I said, the trial begins tomorrow. The judge is going to not only act as the judge, but the jury, so to speak, as the judge decides the questions that the jury would normally have to decide. And obviously, if he finds Mr. Ibarra guilty, I'm sure the judge will give him the presumption of innocence. He will also met out the punishment that he deems appropriate in this particular case. Horrific story, sad story, could have been preventable. Obviously, Mr. Ibarra was arrested in New York for not riding a scooter, I think, with a helmet on, but it was still a felony because there was a child on there, but he was released, made his way to Georgia, and then here we are. Now, this trial of Laken Riley will be live streamed. We will bring it to you live, so come here to Crime Talk, and you'll be able to watch the trial in its entirety, coverage from beginning to end. Next on the docket, an update on the Daniel Penny trial. #free Daniel Penny. Now, a Marine veteran who served with Daniel Penny, the chokehold suspect, took the stand Thursday during his trial in the manslaughter charges as it regards to the death of Jordan Neely. Well, his former Marine Corps buddy, Joseph Cavalier, a former Marine Corps sergeant, said that he had given Penny martial arts instructions and explained a blood choke designed to knock out an aggressor in just a few seconds, with pressure to an artery, which he said is never held more than about 5 seconds in training. That's different from an air choke, which applies pressure to the aggressor's Adam's apple and can be held for minutes. Now, prosecutors showed a picture of the subway chokehold, and Cavalier said it looked like an attempted figure 4 blood choke. However, Cavalier said Penny's arm could be putting pressure on Neely's trachea instead. But on cross-examination by the defense attorneys of Mr. Penny, Mr. Cavalier said he agreed that someone could be placed in a chokehold for more than 13 seconds and not lose consciousness if the person performing the hold wasn't applying pressure. He also said that while Marines are told not to apply a chokehold for longer than 5 seconds in training, that doesn't apply to real-world scenarios. And it was asked, quote, "Is there any point Mr. Penny appears to be applying a blood choke fully to Mr. Neely to go unconscious?" Question, quote, right? And then the attorneys showed the witness pictures and video images. And Mr. Cavalier responded, "Not from what I can see." When asked if there was any reason why the hold should be released completely before Penny was 100% convinced that Neely was no longer a threat, Mr. Cavalier said the decision would have been up to Mr. Penny's best judgment. If you release the hold too soon, there could be a struggle, Mr. Cavalier noted. Well, after the video played again, Cavalier said that at the start, Penny did not appear to be applying as much pressure as he was at the 1 minute 43 second mark when Neely started struggling. And then he relaxed his grip again. Under redirect examination from the prosecution, Mr. Cavalier backed off an earlier exchange in which he suggested Penny could have been holding a botched blood choke. So based off just the assumption that he was applying pressure, yeah, it could have been some kind of air choke, he said, adding that the Marines don't teach air chokes. Anyway, the training we teach we taught while they were in the military, was modified based upon the situation that they were in fact facing. The trial started a little late today because a juror was delayed, and the jury was shown a clip of a body cam video that had been played earlier but missed the sound due to some technical difficulties. In it, a witness told police about Mr. Neely's aggression and the death threats that he made to everybody on the train. Quote, he told like everyone that he had like a rough day and that he don't care what happens today. He don't care about going to jail, but that someone's dying today, the witness said, end quote. Another witness complained to the responding officers about their delay responses. Everybody, I was calling 911 and they took a long time to come. He tried to resist him while somebody came, but they took long. Dude got up and saw he was about to hurt somebody, and he got up and restrained him. That witness added, referring to Mr. Penny, and he was trying to restrain him until the police arrived. So going into the sixth day of testimony, the prosecution has already called 31 people. I think it'd be fair to say not all of the testimony is going the way the prosecutors hoped it would. I think it's going quite well from what I've seen as it relates to Mr. Penny's defense. I seriously hope that he is found not guilty. Normally we reserve judgment. In this particular case, hashtag free Daniel Penny, all right? He was a good Samaritan. He shouldn't be prosecuted for some guy with mental health issues on the train threatening somebody. He took action that he thought was appropriate, as did apparently just about everybody on that train. And then to turn around and get prosecuted is absolutely ridiculous by that joke of a district attorney, Mr. Alvin Bragg. Anyway, that's how I feel about that case. Next, the depravity of man, what one person can do to another. So a 30-year-old man has been charged with special circumstances murder for the execution of a couple in California, setting their bodies and their cars on fire in the desert in two different Southern California counties, and then stealing nearly $250,000 worth of luxury watches, handbags, and clothing from the couple's home. Please meet Hang Tu Gong, G-O-N-G, of Glendale, California. He's been charged with 2 felony murder counts of murder, 1 felony count of kidnapping, 2 felony counts of arson of property, and 2 felony counts of first-degree burglary. He's also been charged with 2 felony special circumstance enhancements for committing multiple murders, 1 felony special circumstance enhancement for committing murder during the commission of kidnapping, and 2 felony enhancements for discharging a firearm causing death. So how did we get here? Well, Mr. Gong is eligible for a maximum sentence of life without the possibility of parole or even the death penalty. Now, in the special circumstance murder cases, the Orange County District Attorney's Office convened a special circumstances committee after the preliminary hearing was held to determine whether to pursue the death penalty. The process includes a presentation of the case by the prosecutor as well as from the defense. Anyway, the district attorney will make the ultimate decision whether to pursue the death penalty after going through the process. And if the decision is not to pursue death, the maximum sentence is life without the possibility of parole. So Mr. Gong is scheduled to be arraigned on December 2nd there at the Santa Ana courthouse. And then on October 15th, it's alleged, of this year, a family member of 37-year-old Kun Lun Wang contacted the Bree Police Department after not hearing from him for several days, which was quite unusual. The family member told police that Wang had disclosed that he was owed about $80,000 by Mr. Gong, a business associate. Well, after not hearing from Wang, his family members contacted Gong on October 12th of 2024, who told her Wang and Wang's wife, Jin Lee, never showed up for a trip to New York to meet with another business associate who could give Wang the $80,000 that Gong owed him. Well, Wang's family were not aware of any trip to New York City. Anyway, the family members contacted Gong again after seeing a man on Wang's patio on surveillance video on October 14th of this year, but Gong denied that that was him. And then her access to the video system was, in fact, then cut off. Now, the Bree Police Department investigator led to Gong's arrest at the Los Angeles International Airport when he returned from a trip from Seattle. Then on October 12th, Gong is accused of meeting Wang in the desert, shooting him in the head, and then putting Wang's body in Wang's Tesla and then driving back to Wang's home. Gong is then accused of attacking Lee with a hammer and hitting her while forcing her to give him her phone passwords. Gong is accused of putting Lee inside her own Tesla, taking her to the desert area in the San Bernardino area where he shot her and then burned her body. Gong is accused of then returning to retrieve Wang's body from the home and disposing of the body in the desert in the Riverside County area, as well as burning his body as well. Gong is also accused of taking the couple's two Teslas to different spots and setting them both ablaze. Well, after getting rid of the bodies and the two Teslas, Gong is accused of returning to the home back in October of 2024 and stealing nearly $250,000 worth of watches, shoes, handbags, and clothing. The police said in a statement, depravity does not adequately describe the callousness involved to kill a human being and then drive around in the victim's own car with the body inside in order to carry out the rest of his plan. No one deserves the fate of being executed and then set on fire in the middle of the desert in a desperate attempt by a killer to cover up his crimes. Needless to say, the district attorney and the police say they are committed to solving this case, obviously, and to bringing justice to all of the loved ones. It's heinous, man. That's cold. That's cold. That's death penalty type stuff. It really is, ladies and gentlemen. And whether you believe it or not, believe in the death penalty or not, that's the kind of stuff that gets you the death penalty. Multiple murders, just absolute callousness, premeditated planning, cover up. Mr. Gong, not looking good for you, buddy. Next on the docket, this day in legal history. On November 14th, 1968, Florida's stop and frisk law was upheld as constitutional, which allowed police officers to stop, question, and frisk individuals suspected of criminal activity. This ruling impacted policing tactics nationwide and was foundational in the later case of Terry v. Ohio. Right? You've heard of a Terry stop. Then on November 14th, 1986, the Anti-Drug Abuse Act took effect, establishing mandatory minimum sentences for federal drug crimes. And this legislation shaped U.S. criminal justices by increasing prison sentences for drug offenders, although it later faced criticism for contributing to mass incarceration. Yeah, that's turned out so well. Don't get me wrong, drugs are evil. But mandatory minimums didn't exactly deter a whole lot of anybody. Just saying, you got to go straight to the source. You got to stop it before it gets here. That's just my 2 cents worth, for whatever it's worth. Anyway, continuing, on November 14th, 1991, the city of New York established a specialized narcotics court to address the overwhelming caseload of drug-related crimes. These courts were the early efforts in the U.S. to treat drug offenses with targeted interventions, influencing later drug court models around the country. Now, drug courts are very, very interesting. There's so many specialty courts these days. They've got veterans court. If you have a case and you have a veteran, if you have issues, they're going to get you there. You've got drug cases. You got DUI cases. You got all kinds of specialty drug courts. I'll be honest with you, personally, I try to avoid those. You're eligible for that. Go do the treatment. Go do what you want to do. You don't need me there for it. And then you see, and I have mixed feelings about it. For example, people show up and they have like reviews and they do it with everybody in the courtroom, say for like a drug court, and they get rewards. They get rewards for doing what they're supposed to do. I got a little mixed feeling about that, because you have other clients on probation that they're in a specialty drug court and they're just expected to show up and do their UAs. But if they have clean ones, they get like free gift cards to Starbucks. I don't know. Shouldn't they just do what they're supposed to do on probation? I get it. Drug addiction, any kind of addiction is very, very tough to overcome. But I don't know. I think it's a little too touchy-feely for me. But if it works, I guess we'll see. They keep spending money on them, diverting everybody to specialty courts. I like stuff where did you do it or not? That's what I want to do. Next, our dumb criminal of the day. They get points for creativity. So we have 4 dumb criminals today, but they're all acting together, so we'll lump them into one. Ruben Tasmarian, Ariat Chirkikian, Vahe Muradaharian, common spelling, and Alfaya Zuckerman were arrested Wednesday on charges of insurance fraud and conspiracy. but the police don't know who was the one dressing up as the bear. That's right. You heard that correctly, ladies and gentlemen, the bear. So the California Department of Insurance got involved, and they are accusing these suspects of scratching and tearing up 3 highly expensive vehicles and then filing bogus claims to insurance companies to collect $141,000 in damages. What the insurance commissioner people allege is that on January 28th of 2024, these individuals filed an insurance claim saying that a bear had gotten into their 2010 Rolls-Royce and ripped it apart. And they even provided video of it. But when the investigators took a closer look at the video, they determined that the bear wasn't real. It was a person wearing a bear costume. Anyway, the alleged fraudsters committed the same crime at least 2 more times on 2 different cars, one being a Mercedes and a 2015 Mercedes, and another one being a 2022 Mercedes. And the insurance company, or the insurance commissioners, actually hired a biologist to make sure that the bear videos weren't in fact a bear. And it was determined that it was in fact a human in a bear costume. Needless to say, everybody got they got search warrants, and guess what they found in one of the suspects' homes? That's right. Look at that. The bear costume. Can you believe it, ladies and gentlemen? The bear costume. Creativity. I don't know. They must have been high. I mean, they had to have been on drugs, right? California. I don't know. Maybe. Can you imagine how this came around? 4 people sitting around. Wow, we could really use another $140,000. Wow, how should we do it? Should we go get a job? Should we make some extra money? I got an idea. Let's claim a bear rips apart our car. Yeah, but where are we going to get a bear? A bear wouldn't really do that. How are we going to do it? Don't worry. I'll get a bear costume and we'll videotape it just so everybody knows that a bear did it. These people had to be on drugs, ladies and gentlemen. Unbelievable. All right, that's all I have for you today. Thanks for watching. We'll see you next time. And remember, the Constitution matters.